Please be seated. All right, the final case on the docket is ABRAMS, SCULLY et al. Versus Town of PONCE.
Good morning, and may it please the Court, I'm Alan Watts of Cobb & Cole, appearing for the appellants, and if I can do it, although I understand the clock is not
Clock's on. Tell me how much time you'd like.
I'd like to reserve about 6 minutes for rebuttal.
Okay. I'll give you a heads up.
Thank you. I represent Alex Abrams, who owns a couple of condo units in the East Wind condominium.
You know, I tried to find in the record where it indicated when these folks had purchased their property. Is that in the record?
It is. It's in their deposition testimony, I believe. And each of them purchased prior to the ordinances in question.
Prior to all the ordinances, prior to the 77 ordinance?
Oh, no, sir. No, not prior to the 77 or 85, but prior to the 2000.
After the 85. So in the window when you contend that it was most clear that this was a permitted use.
Yes, sir.
Okay.
Yes,
Let me ask you about this 85 ordinance.
Yes, sir.
That's where they dropped, I guess, what was it, Roman numeral 5 or section 36? Or
36 and 36.4.
Made a subtle change to the definition.
A subtle change, but I don't think a material change.
Okay. Well, let me ask you about that, because that seems to be at the crux of the case, is what that ordinance means. Let's break it down and let's to the first sentence, I guess, and the second sentence. You know what I'm talking about, right?
Yes.
Let me ask you about a typical, bed and breakfast that is, was built originally to be a single family dwelling. And subsequently, like the one up in Fernandina Beach, I'm sure you've seen these bed and breakfasts, 2-story, house with a big wraparound porch, but now they're renting out rooms to transients.
Yes.
Would that fall? Would that be a dwelling under the first sentence of this definition?
I don't think so, because the individual units that are being rented within it are the bedrooms. Now, there is a common area just as there is a lobby. There's a dining area just as there is a restaurant, if you were speaking about a hotel. But I think the design...
I guess the reason I was asking you that is because the first sentence uses the word design.
Yes, sir.
Designed to be occupied by one family, which, means to me that, design means design. I mean, whatever it was originally designed to be, that's what they're talking about in the first sentence.
Actually, I think they're rewriting their bed and breakfast ordinance in PONCE right now, but that's off the point. I take your point. A building that is originally designed for a single-family residence could be converted to a bed and breakfast, I suppose, but
there are a lot that have. Yeah.
The fire codes would require, because of the separate occupancies of the rooms and one resident not having control over what other ones do, the codes would require some separation.
All right. Let me ask you about the second sentence now. All right. Now, the first sentence uses the word design. The second sentence uses the word intended.
Yes, sir.
It talks about or other buildings intended for short-term occupancy by transients.
Yes, sir.
Okay. Now, your bed and breakfast is clearly excluded under that, isn't it? I mean, even if it is included in the first sentence, it's clearly excluded by the second sentence, right?
If I had to make a call on that, Your Honor, I would say the bed and breakfast is like a boarding house in the sense that you have the exclusive right to occupy a bedroom, but you do not have, as a resident, independent cooking facilities within your own bedroom. You're not supposed to anyway.
I thought in your brief you were making an argument that was honing in on the nature of the structure as opposed to the owner's subjective intent.
I do make that argument, but I think the argument actually is a bit broader than just the structural. I think it also goes to the points that you asked me about, the intent for use. And I think that if the intent is that the entire structure be turned over to a family for a week or a month to live independently there, but not to make it their permanent resident, I don't believe that that's inconsistent with the definition of dwelling in the 85 ordinance, or for that matter in the 77 ordinance, but for the additional proviso in the 77 ordinance that was section 36.1.
Yeah, I know 77 doesn't have that one in there, but that's why I'm most interested in 85.
Yes, sir.
Or other, I mean, the critical part of that ordinance is or other buildings intended for short-term occupancy by transients. Well, whose intent are we talking about there? A building can't have an intent, so.
No, but the occupancy is subject to different codes depending on the nature of the occupancy. And
Okay, well,
single-family home.
I'm not sure whether that answered my question. Whose intent does the ordinance refer to? Does it refer to the intent of the owner?
I believe that it does, yes, sir.
Okay. Well, then why don't your clients fall within this exclusion? In other words, they have buildings that are not hotels, motels, or tourist courts. But they're buildings clearly, and they're intending to use them for short-term occupancy by transients.
The answer, I think, lies in what you have to do if your intent. You can't simply have a subjective intent and have that determine whether or not you're violating the ordinance. It has to be the permanent setting aside of the use for a different intent than occupancy by a single family with independent living facilities for cooking, bathing, sleeping. A condo unit has those kinds of facilities within it, and it can be rented out for independent living. A bed and breakfast is different in terms of what the owner must do to set it aside. Most towns, and I think PONCE INLET is still in progress, but most towns have separate regulations that apply to a bed and breakfast usage.
You know, I don't mean to be difficult with you, but in other words, don't we have to give some meaning to these words here in this exclusion, in this definition?
Well, we begin with what is the appropriate standard for review.
So you say it's de novo, they don't seem to disagree with that.
They don't disagree with that, but I mean the standard for judicial scrutiny of a zoning ordinance is to construe it most favorably to the free use of property. And to strictly
If we
construe.
find an ambiguity in it, is that? I mean,
In the case of an ambiguity, since the violation of a zoning ordinance subjects you, actually it's a misdemeanor to violate an ordinance. It does subject you to fines and liens on your property if you violate an ordinance. So from a due
Okay, well,
process
assuming that
standpoint-
you're right about that, tell me one way to construe this is the way the city construes it, which is that your clients have buildings, as that word is commonly understood.
Yes.
And they're intending to rent those buildings short-term for occupancy by tenants, which pretty much tracks the language of that phrase. What other construction do you think is reasonable?
Suppose their intent is to retire and to generate what rental income they can until the time of retirement to service the mortgage, and in these days to service the ad valorem taxes and the insurance on it. What happens when the city switches gears on an ambiguous definition and says that what we have heretofore tolerated, we now reinterpret to say that it's no longer tolerated? And I'll give you a specific example. The findings.
I'm just trying to find out what the other way of interpreting this is.
Well, I've given you a number of authorities with definitions that I don't think any are exactly identical, but they're taken from zoning ordinances and restrictive covenants, both within and without the state of Florida, in similar situations. And in each of those cases, the courts have found that there's nothing in this language that prohibits the short-term vacation rental of the
All
property.
right, let me ask it this way, Mr. Watts. You seem to agree that a hotel, a motel, or a tourist court is not a dwelling as defined by the 85 ordinance. You with me so far on that?
No, sir, and there are specific definitions of what those facilities are.
Right, but they're not dwellings under this ordinance, a
They are
hotel,
not.
motel, or a tourist court. So
They are not.
then that leaves us with the catch-all. Other buildings intended for short-term occupancy by transients. Does that mean nothing? Does that have no meaning in your view?
In terms of hotels, motels, and tourist courts, each of those has a specific definition
Right.
in the zoning ordinance. Under the rule of justum generis, whatever that other facilities means has to be construed in the same light as the three words that preceded, hotels, motels, tourist courts. We know specifically what their definitions are.
What does that mean, that it has to be construed in the same light? It has to
Others
be-
of the same kind, I
Right.
think is the literal
So
translation.
why isn't a building that is capable of being used as a single-family house, why isn't a building that's being rented out on a weekly basis to tourists the same as a motel, or like that, so that it can be construed in such a manner?
Because violating the ordinance can't depend upon the subjective intent of the owner this week or that to reside in it with his own family or to rent it out to another. Many of these places are weekend places. Weekends are not planned there by the owner. They may be rented out. In neither case is the occupancy more than transient. Can you say that the owner himself is in violation of the ordinance if he uses it for only a weekend or for less than 28 days? There's no difference really in the effect on the public health, safety, and welfare if it's the owner who's there for less than 28 days or whether it's a family that occupies it for their vacation and pays consideration to the owner. In either case,
Well, it has to be a transient, and that's a term of art. The owner's not a transient, right?
in the first of the challenged ordinances, the town defines a transient as anybody who doesn't own a house. Now, it doesn't matter whether the lease is for a week or 5 years.
That's not defined in the 85 ordinance, right?
No, that was added in the 2003 ordinance.
The definition.
The definition of a transient
Right.
was
I mean, you
made.
got to kind of look at this 85 ordinance, kind of as a standalone ordinance, right? Your clients are saying that they have vested rights under the 85 ordinance. They
And the
didn't get their
town thought
vested
so.
rights under the 77 ordinance, because that really wouldn't help them, right?
Well, unless they preceded 77, because under the 74 ordinance, transient rentals were expressly permitted.
But they're saying that they purchased their houses in the window between 85 and 03, and that's where they got their vested rights from, right?
Actually, the only time that transient rentals have ever been expressly forbidden was between 77 and 85. When you speak of the window, that was the window.
Well, that was a window during which they were prohibited. I'm
Yes.
talking about the window within which they clearly were, or they were arguably permitted, right? It was 85.
Before that and after that, they were permitted, and under our view. And I think that's the town's view also, because if you go to page 2 of the 03 ordinance, it says, whereas it is the intention of the town council to reinforce the definition of dwelling. Now, the problem is there's nothing in the text that follows up on that predicate. And then it says, whereas this ordinance provides a phase-out period of 1 year, because the effective date of this ordinance was a year after its adoption. What are they phasing out? If not, the prior interpretation of what a dwelling was. And David Hooker, the code enforcement officer, said, I don't have enough here to enforce. That was an internal memo.
Is the town bound by that? Is the governmental entity bound by the misapprehension by a code enforcement officer of
No,
that
sir.
ordinance?
No, sir, the law is what it is. And it's
That's
ultimately
really
for the
that's
court.
really what we're looking at, right?
That's your role.
Right.
And you do it de novo, and you do it by a standard that favors the free exercise of private property rights.
Well, isn't that though only if we find an ambiguity? If it's not ambiguous and it's not otherwise unconstitutional,
If it weren't
we don't employ a
ambiguous,
rule of construction, right?
if it weren't ambiguous, the town would not need to reinforce the definition. as it found that it was doing in the 2003 ordinance.
You have about 5.5 minutes.
Yeah, I'm I'm not down the line very far, but let me just say this. What the town said it was doing, if you go to the agenda for the meeting of on the 2003 ordinance, it says ordinance 2003-03 providing for comprehensive regulating and licensing program for short-term rentals of properties in the R1, R2, R3, MF1, and MF2 classifications. The problem with that is that that ordinance didn't do any of those things. That's what the town thought it was doing. That's what you would have found if you had inquired into what this ordinance was doing, as the trial judge said we should have done. But you can't simply decide one day the law tolerates rental of dwellings, and the next day it forbids it. You can't. This case is not about the power of the town to forbid short-term rentals, given a properly enacted ordinance, subject to whatever grandfather rights my clients may have. That's the Rollison case. Town can do that. Problem is, it hasn't. It has simply declared by fiat.
What is the genesis? I know there's the 03 or 04 ordinance have a grandfather provision in them.
Yes, sir.
What is the genesis of the grandfather? Supposedly, they call it a grandfather clause or grandfather law or something in the 3rd District case. Where does that come from?
That one came from the fact that before they adopted the regulations in Key West, a definition of short-term meant something that was rented for short terms for more than half the year, I think.
Well, I guess my question is the whole vested rights concept of constitutional magnitude, is that where it comes from? And have the cities just put these provisions in there because they know that essentially, people have that right anyway?
Well, actually, I don't think that's the case. If you go back in U.S. constitutional law all the way back to Mueller against Kansas, which is a century-old case, it says there's no constitutional right to continue a nuisance. But nobody says that these rentals are nuisances. They may have aspects that can be properly regulated. And in certain zones, they could be entirely forbidden. But it would be subject to the vested rights, it not being an inherent nuisance. I think the briefs, as you pointed out, the briefs raise, and each of us has addressed all the issues. Better save a little bit of time to address whatever they're going to say.
You have about 2.5 minutes.
Beg pardon?
You have about 2.5 minutes left.
Thank you.
May it please the court, Michael Cicchetti, co-counsel Audrey Harris, Doran Wolf, Ansay, and Cundid. For appellee, the town of Ponce Inlet. We also have with us town council member Gary Comfort and interested town citizens. This case is about a vested right.
Is the 85 ordinance ambiguous?
Not at all, Your Honor. It's clear in its definition.
What does it mean when it says a dwelling is a room or rooms in a building forming a separate and independent housekeeping establishment? What does that mean? I mean, is the dwelling the room or is the dwelling the building?
A dwelling is a combination of rooms ultimately forming a building.
That's a pretty inartful way of saying that, right?
Your Honor, it's a commonly used definition of dwelling.
Yeah, well, I mean, just because they perpetuate an ambiguity from the beginning of time doesn't make it any less ambiguous, right? I mean, it says a dwelling is a room or rooms. How could the dwelling be a room within a house?
Well, a room could be a dwelling in the sense that you could have a studio. You have a one-room dwelling.
If it's got a sleeping facility, a sanitary facility, and a kitchen all within the room, I guess.
That's correct.
What does it mean in the second sentence where it says, for other buildings intended? Whose intent are we talking about there?
We're talking about the intent of the code, ultimately the intent of the town council, the town citizens there, that a dwelling...
You think that intent there is talking about the intent of the town council?
The intent on the prohibition of that type of use.
Well, so the property owner is supposed to figure out what the town's intent is based on
the property
talking
owner,
to them, or what?
the property owner, in conjunction with the town by review of the code, should analyze the definition of dwelling if, in fact, they would like to construct.
Okay, I'm just talking about the phrase "or." I'm kind of dissecting this sentence. Okay, it seems that the critical phrase is "or other buildings intended for short-term occupancy." You agree with me? That's a critical,
Absolutely.
crucial phrase.
It's dispositive of the issue.
Right. Now, a building can't intend anything, right? It
That's
has to be
correct.
people. You could construe that other buildings intended means other buildings that the designers intended to be used for short-term occupancy, or you construe it that other buildings that the user or the owner intends for short-term occupancy, and maybe there's other constructions of it. What do you think it means?
I would say it's a combination between the intent of the town, along with the corollary intent of a developer, of a homeowner, to understand what the term dwelling would encompass, and specifically that it would include anything with a use akin to the more specific term.
Was the short-term rental to transients of homes in the town of Ponce Inlet in the zoning categories that council's clients are in, was that prohibited between 1985 and 2003?
Yes, Your Honor. It was prohibited by the very definition of dwelling.
Why did the town's agents, let people do it?
It was an enforcement problem. At first, and the record would state, and the record actually begins with the code enforcement officer, Dave Hooker, reviewing the problem based on complaints. As far as before Dave Hooker, I would have to testify to matters that were...
So Mr. Hooker looked at the ordinance and he couldn't figure out what it meant. Is that what happened? Or?
Mr. Hooker more accurately looked at the ordinance and had issues with its enforcement. That's why that would be the genesis for Ordinance 0303 and 0401, which established more of a regulatory framework to assist code enforcement in stopping...
So why did they enact an ordinance in 2003 that carried forward essentially the same definition of dwelling?
Because the town believed, and accurately, that the definition of dwelling is sufficient to prohibit the short-term rental, short-term occupancy by transients of dwellings within the residential zoning classifications. And I use residential in the catch-all sense, as these properties are all zoned R1 or multifamily. A multifamily designation is also a residential designation. So really, the 0303 definition recognizes that the dwellings are prohibited from being rented on a short-term basis, used for short-term occupancy, and establishes a regulatory framework to assist code enforcement in catching offenders, essentially.
In the 85 ordinance, is short-term occupancy a defined phrase?
It is defined in the sense that the definitional section of the LUDC in section 212.
Is that the 85 ordinance or is that the 03 ordinance?
The 85 ordinance also defines short-term and transient. It makes a dictionary reference. It does not expressly define it within the LUDC, but all words that are not defined are ultimately defined by Webster's
Well,
dictionary.
what does short-term mean?
Short-term, it's in the record as being for a period of less than 6 months.
Well, that's the construction that the city gave to it in 85 or something like that, right?
That's correct.
Because they did that 50% rule, is that what they did?
No, that was Rolliston versus City of Key West. Ponce Inlet had never had an administrative return.
Well, how'd they come up with 6 months?
That's based on the definition 1985, or definition of short-term provided by Ordinance 8527.
Okay, I thought you just told me it wasn't defined in the 85 ordinance.
It wasn't expressly defined within Article 2 of the LUDC, but there is a provision in Article 2 which would reference the reader to Webster's dictionary for each term that is
Well,
not expressed.
what does Webster's dictionary say short-term means?
It doesn't say 6 months.
For a period of less than 6 months.
That's what Webster says, that short term means that.
That is the definition, and it is in the record, brought out through deposition testimony of each of the appellants.
I'm not sure that I appreciate what you're saying. In other words, there were witnesses that testified in this proceeding that gave their opinion about what short-term was, right?
That's correct, Your Honor.
Okay, but you're not saying that Mr. Webster says that short-term means less than 6 months.
That is the dictionary definition.
Which version of the dictionary?
It's the 1983 edition.
Of which kind of the Webster's?
Webster's 7th, I believe it's 7th Collegiate Edition.
The Collegiate New World Edition?
It is referenced in Ordinance 85-27.
So are these folks allowed to rent their dwellings for less than 6 months in the period from as long as it's not less than 6 months?
Greater
Or
than
no,
6
no,
months,
as long
that's
as it's not
correct.
greater than 6 months, they're allowed to do that?
That's what a dwelling would be allowed, and it's admitted that these units are in fact dwellings.
They're not allowed to do it less than 6 months.
Under the 85 ordinance. The 0303 ordinance changes the definition of short term to 4 consecutive weeks. And that's by ordinance 0303 and 0401. Now, appellants make much of the argument that Ordinance 77-10 included Article 5, Section 36, with regard to rental units, and stated that any residence, apartment, or living unit, and I emphasize residence, apartment, or living unit, not dwelling.
I'm not really appreciating why you all even got into the 77 ordinance, except for maybe to confuse the court.
I agree.
These people all bought their houses between 85 and 2003, right?
I agree, Your Honor. And
So I guess they're arguing that because you all dropped that Section 36, that there was a conscious decision to change the rules back from 85 to 77. Is that the law?
that's an accurate representation of the argument. I disagree with the law. I disagree for 3 reasons. First and foremost, the Ordinance 85-27 brought forward an entirely new land use and development code for the town. If you compare 77-10 and 85-27, you see that there are ordinances which attach and incorporate totally new LUDC provisions, and they regulate short-term rentals in a different manner. 85-27 includes Section 501, which states that a requested use or structure that is not expressly permitted in a zoning classification is prohibited in that classification. It also revised the definition of dwelling to include a durational limitation. The briefs make much of, appellants' briefs make much of the lack of a durational requirement. However, clearly the ordinance 85-27 and that definition of dwelling includes the durational limitation intended for short-term occupancy by transients. The definition and
What do you
section...
say about this argument that when you have a catch-all phrase, you know what I mean by that?
Yes.
The 4 other buildings in this case, that under that Latin, doctrine that we all learned about in law school, that you look at the more specific matters that are contained within that phrase, and that you construe the more general to apply only to like things. What do you say about that argument?
I say that argument actually reinforces the town's position, that the term other buildings takes color from hotels, motels, tourist boards. So we should put any reader of this ordinance, of this definition, on notice that, hey, a dwelling cannot be operated in the manner as a hotel, a motel. Essentially what we're talking about here is tourist accommodations. Any reader reading this, even without a legal degree, should be able to read this ordinance and clearly see that a dwelling should not be used in the manner of a tourist accommodation. In fact, I would note to the court that there are other definitions of dwellings available. The state recognizes that through the Division of Hotels and Motels, Chapter 509, recognizes resort dwellings, resort condominiums. The town consciously chose not to include such provisions within its LUDC and more affirmatively reinforce the definition of dwelling to specifically exclude any building intended for short-term occupancy by transients. Now, if you, with a review of all the deposition testimony of the appellants, you'll see that none of the appellants reviewed any of the LUDCs. In fact, during deposition, they testified that at the time we placed the depositions in front of the appellants, that was the first time they saw any of the land use and development codes for the town. No appellant at any time requested an opinion of the town code enforcement officer.
I guess you're getting to your argument that in order to establish vested rights, they have to establish the elements of equitable estoppel.
I'm not getting into that argument. I'm getting...
That's an argument you made in your brief.
That's correct, Your Honor.
Is that really the law?
I would say that there was not an estoppel here.
Aren't we talking about apples and oranges? Isn't equitable estoppel a theory under which, a landowner may persist in a use that was essentially approved by the town And vested rights are something that really has nothing to do with, reliance. It just has to do with the fact you all have it in your code, that a use may continue, and sometimes those uses are amortized over time and things like that, right? They're two different things, right?
I absolutely agree, Your Honor. Section 541 of the LUDC refers to vested rights in the context of a lawful conforming use.
And you concede that if under the 85 ordinance, these people were permitted to rent their dwellings short-term to transients, that they enjoy vested rights under the 03 and 04 ordinances.
That's correct, Your Honor.
Okay.
If the definition of dwelling allowed for short-term rental, they have vested rights. If the definition, by definition, does not allow short-term
It
occupancy,
doesn't make any difference whether they read the ordinance before or anything, right? I mean, if they could do it in 85, between 85 and 03, they can continue to do it.
absolutely, Your Honor. I bring in the equitable estoppel, though, because all of the cases that deal with administrative reinterpretation of an ordinance generally go through the analysis of an equitable estoppel case, and this is where the courts generally confuse the issue, and vested rights and equitable estoppel become somewhat more interrelated. And in Rollison, if you read the opinion, you'll see that it establishes somewhat of a framework of equitable estoppel,
I know,
but
but that was a
ultimately,
vested rights case, right?
but ultimately it ends on a vested rights case with a very, very clear administrative
Well,
reinterpretation.
somebody confused that court, and, we're trying to keep y'all from doing that to us.
Thank you. Considering all the foregoing, I would submit that the trial court properly entered summary judgment in the town's favor when it looked at the definition of dwelling, found that short-term occupancy by transients was never a lawful use of the property. And since it's not a lawful use of the property of the dwellings that are owned by the appellants, that they are not entitled to a vested right pursuant to Section 541 of the town LUDC. I would submit that all of the notice issues with regard to the subject ordinances, Ordinance 03 and 0401, are rendered moot if the court finds that since the inception of the town, or at least since 1985-27, that the definition of dwelling specifically excluded from that class of properties, that class of buildings, any building that was intended for short-term occupancy by transients. I will also note that a majority, all of the cases, in fact, that the appellants cite in their brief, especially in their reply brief, do address the definition of dwelling. However, all of those definitions of dwelling do not include a durational limitation. They're much more specific definitions of dwelling. They go by dwelling, multifamily, dwelling, single family, dwelling, tourist accommodation. And I'm speaking generally. There's a litany of approximately 10 cases. What's important here is that the definition of dwelling for the town of Ponce Inlet is an overarching definition of dwelling that includes this durational limitation. Therefore, no dwelling within the town, whether it's a dwelling, single family dwelling, multifamily, can be utilized for short-term occupancy by transients. Therein lies the distinction. All of the other cases cited by appellants have general categories of dwellings with distinctions within each, whether it's a single family or multifamily distinction. I would also state that the town has allowed short-term occupancy by transients in the T1 zoning classification. That's the use most akin to short-term occupancy by transients. That, in fact, is what's allowed by the town's comprehensive plan and its planning and zoning department. And I would, again, with regard to Ordinance 1977-10, and I understand, Judge Zillipi, that you do not feel it comes into play, and I would agree.
I didn't say that. I was just asking you a question.
I would submit that it does not come into play with regard to this matter. But I will note within that definition or that section, any residence, apartment, or living unit, those are defined terms within the town land use and development code under Ordinance 7710, residence, apartment, or living unit. The term dwelling is not within this exclusion. Section 36.1 states any residence, apartment, or living unit can be leased or rented for less than 1 month in the T districts only, and are subject to the licensing of the hotel and motel industry. Again, dwelling is not included within this provision. So any argument as to its removal by Ordinance 8527 is of no effect, because this doesn't affect dwellings. It affects these specifically defined terms. And dwelling was a defined term in Ordinance 7710 also, but not included in this section. I do believe there's statutory construction principles and interpretation principles there that would state that where a provision is included in one part of an ordinance or a code and not specifically included in another part of the code, that the legislative intent there would be that that definition is not chosen to be included there. Also, I would refer the court to the definition of dwelling pursuant to Ordinance 7710, a house, apartment, or building used primarily for human habitation. The word dwelling shall not include hotels, motels, tourist courts, or other buildings for transients. Obviously, the definition changed dramatically between Ordinance 7710 and Ordinance 8527, specifically with the intended for short-term occupancy by transients. In closing, I would submit that the use of a dwelling as short-term occupancy by transients was never a principal permitted use within the zoning classifications that appellants' dwellings reside in the residential and multifamily zoning classifications, the residential zoning classifications. As far as bed and breakfasts, that is actually a defined term within the Town Land Use and Development Code that is separate and apart from the definition of dwelling. As far as any phase-out period regarding the Ordinance 0401, a phase-out period was essentially a warning period. The town says in approximately 1 year, we're going to begin increased enforcement of our short-term rental restrictions. We'll have our regulations in place, and we'll have a methodology where we can enforce our restrictions. And with regard to a review of Dave Hooker's deposition, it was more of an issue of regulation rather than the actual restriction. The use of the property was never allowed. The use of a dwelling was never allowed for short-term rentals. It was merely regulatory enforcement became a difficulty. There were no guest registers. There was no scheme where the town could determine whether or not an individual, a property owner, was violating the zoning ordinances. Therefore, a regulatory scheme was necessary, whereby guest registers would be maintained, leases would be maintained, and then for reference, the town could determine whether or not a lease was executed for in excess of 4 consecutive weeks. It's a rather simple regulatory ordinance.
Thank you, Councilor.
Thank you.
Let's see what I can do in 2.5 minutes. The question about estoppel is, I think, properly answered. The law is what it is, and in terms of a zoning ordinance, if it's to be enforceable, I would refer you specifically to the part of our brief on pages 22 and 23 of the principal brief, the Juno Beach case. I think it addresses a lot of the questions that you asked me on my argument in chief about is it ambiguous. And the 4th District ends up by saying the effect of the trial court's decision was to amend the ordinance as the town would like to have it read, not as it read.
Well, that ordinance was different than this one, right?
Well, I'm not sure it was. It defined a dwelling as any building designed primarily for residential occupancy, not including a hotel, motel, club, or RV. And it excluded...
Well, it doesn't have the or other building intended blah, 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 critical language in it that this one has, right?
Well, we think...
And they got an expert witness and put him on the stand and had him give an opinion that was, contrary to what the ordinance plainly said.
Well, what they said in that case was that a timeshare was not a transient occupancy. And the court there also, the 4th District also held that the error lies in the deviation from the plain definitions within the plan and ordinance in favor of after-the-fact expert testimony as to legislative intent to fill in the cracks. Government cannot function in such after-the-fact fashion. Why? Because this is a penal ordinance. Due process requires that there be announced standards of conduct or announce standards to which the conduct of the user of the property must conform. If the definition is ambiguous, then due process requires that it not be enforced to the extent of the ambiguity. The town is free to remove the ambiguity, but when it does, if it provides for prior nonconforming uses, then those uses must be grandfathered until some amortization period has passed or until they're abandoned, whatever the choice that the town makes in providing for the phase-out of prior nonconforming uses. And it may do that, but it can't just abruptly declare them one day the ordinance means this, and the next day the ordinance, we're reinforcing the ordinance, though they didn't. They declared that they were. Last point, the T1 ordinance lists dwelling as a permitted use, yet the town concedes that the temporary use of dwellings has always been permitted in the T1 zone. How can that be if dwelling cannot permit a transient occupancy? They can't have it both ways.
Time is up, guys. Thank you.
Thank you. Thank you all for your arguments.